Today is February 20th, 2025, and welcome to the New Possibilities Hour, part of the Will Work for Food project founded by Natalie Armstrong-Motin. Every week, Jean Lawler and I are delighted to host another cutting-edge webinar for mediators, arbitrators, lawyers, and everybody who negotiates. As you know, there's no charge for these great webinars. Rather, we ask you to contribute to a food bank if you like what you see. And wow, our audiences have been so generous in contributing in honor of our great speakers. One of my favorite parts of the webinar each week is when we announce the running total of just how much our audiences have contributed. Natalie Armstrong-Motin, would you please do the honors?
Absolutely, Geoff. We have raised $690,307.74 to date via donations of our great presenters and audience members.
Just amazing. Thank you all so much. And today we're going to have another great and insightful presentation from Geoff Wells. Geoff is a lawyer on the plaintiff side with the prominent Los Angeles law firm of Greene, Broilett, Wheeler. He's been a lawyer on the plaintiff side for 36 years after having practiced briefly on the defense side for 3 years before that. And very significantly, he is the current president of the Consumer Attorneys of California, one of the largest and most prestigious associations of trial lawyers, consumer attorneys in the country, if not the world. So to share your views with us, Geoff, on ADR topics, mediation, arbitration, whatever you'd care to discuss, we're most interested in hearing your views. Please tell us a little bit about the food bank to which you would like people to contribute if they're in a position to do so. And then on with the presentation. The floor is yours.
Okay, thanks, Geoff, and good morning, everyone, or good afternoon, or good evening, depending on where you are in the world today. I want to start off my topic. Well, LA Food Bank probably never been a more important time for LA Food Bank than with the wildfires that we've had in Los Angeles, Pacific Palisades, Altadena, and it's been a horrific situation. We had 3 people from our office that lost everything. One was my paralegal. Her husband went back in to get the 2 dogs. He got the dogs out and they lost everything. She had a to-go bag, but she realized, when you're to-go bag, you don't think about packing things like underwear. And so she had no bra, 1 bra and 1 pair of underpants and 1 pair of socks. And so it just, out with your life. And you realize maybe at times like this, what's really important actually is your life, as opposed to material things. It's a quick reminder of that. When we deal with our clients in these mediation proceedings, one of the things I've wanted to try and instill in the lawyers in our area in California this year is the importance of really 4 words. And I've added a new word to that, and that is honor, integrity, civility, and decency. And those are words that are so important today with all the billboard lawyering and all the commercials on television and all the stuff that we all know that goes on every day. I'm going to add another word to that after reading the American Board of Trial Advocates magazine about Alexei Navalny, and that word is called courage, and the importance of courage in the practice of law, representing people really on both sides of the aisle. And I think it's something, too, that you want to, if you get a chance, remind the lawyers the importance of honor, integrity, civility, decency, and now courage. And standing up at a time where, a lot of things are being challenged. Judges are being challenged. The lawyers are being challenged. Our whole system of democracy in America is being challenged right now. And so it's important for us to remind all the participants in a mediation of the importance of decency, democracy, and having fairness for both sides getting an opportunity to present their case. In many places in the world, they don't get that opportunity. Geoff had asked me to talk a little bit about what I thought the best mediation practices are. And I actually see 1 or 2 mediators on here that I know quite well. One would be Bob Tessier. I see him there. Good morning, Bob. And one of the things that I've picked up, and I probably mediate somewhere between 20 and 30 cases a year, I would guess. Our firm probably does over 100 to 150 a year. And that is connecting with the plaintiff's counsel before the mediation. I think it's important that you make a pre-mediation call to the plaintiff's counsel, get to know him or her a little bit, get to hear kind of their read on the case. Maybe you'll get some insight about kind of what they're looking for in the case. And then also ask them ahead of time what they think their strengths and possibly what they think their weaknesses are in the case. Most lawyers on the plaintiff side that are prepared will know both their strengths and weaknesses. And if you develop a trust with them that what they can talk to you about in confidence, they'll disclose what those are. Now that could be important because at some point you're going to be talking hopefully with their clients. Geoff also had asked me to talk about whether or not it's important that the client come to the mediation. I mean, I think that's almost a silly question, but I guess it's an actual thing now. So the answer is yes, the client has to be at the mediation. And if the client is a good client, the plaintiff lawyer should want their client at the mediation. And if the client is a bad client, they'll want them there so that somebody can talk some sense into them, because sometimes we have difficulty with our clients, as you might all know. And so sometimes clients have an unrealistic expectation of the value of the case. And even though we work on them to try and lower that expectation, there's always the nicety of having an objective, neutral person look at the facts and the law in the case and maybe have a dose of reality for some of those difficult clients that think that their $200,000 case is worth $2 million. So those are things that are really, I think, a benefit for me on the plaintiff side. The best mediation practice is that early call a day or two ahead of time. Now, what are some of the things that I've seen that are not a good mediation practice, that have kind of feel like they maybe have dropped the ball? Well, one is, gosh, if they, I spent $15,000 or $20,000 on a damages video, and I send that to the other side, and I send that to the mediator on a case. And I've had cases where the mediator hasn't seen the video, even though I sent it to them a week or two ahead of time. That's a disappointing start to the mediation. And many times what might happen is they have to go off, take a break and go look at the tape during the mediation. And that to me is a little bit disappointing, honestly, on that, to see that. The other one would be if I've submitted some key exhibits in the case, photographs, documents, emails, if it's employment cases, some of the key pieces of evidence that are attached as exhibits to the brief, you got to look at those. I mean, you can't say, where is that? I haven't seen that yet. Or, that to me feels like the mediator's not prepared and not invested in looking at the evidence in the case. So those are kind of obvious things. Sometimes mediators will kind of get an idea, like I'm going to use Bob Tessier because I know him and I see him on here. He'll ask me kind of, what are you looking for in the case? And, on the plaintiff side, we have this huge spectrum of lawyers that are between 2 years and 50 years. And they go to these seminars and they go see Nick Rowley or, my partner, Greene or Bruce Broilett or Brian Page. They go and see these guys and they come out of those things all fired up and they think they've become Jerry Spence, and their case is now worth what was 100,000 is now worth 100 million. And they think that that's what they've got to do in the case. So sometimes you got to spend a little time finding out, who those people are. They'll reveal themselves pretty quickly in the mediation, but also to get some ideas that maybe you can try and get an idea of how it help them lower their client's expectation, especially if they're the ones telling the client that the case is worth, hundreds of millions of dollars when it's not. So those are some of the things that that I find that are helpful, that might be helpful for you from the plaintiff's perspective. Obviously, if I have a client that I think is a great witness, I want them to talk to you. I want you to talk to them. I want you to spend a little time getting to know who they are. I had a mediation this week where I had a husband, a gay couple in a wrongful death case. And he was on an AIDS cycle charity ride that was a kind of like a practice ride that was going to be a 150-mile ride, and he's killed on his bicycle on the ride. And I want to have the mediator get a chance to understand the relationship. They were married for 30 years. They had we had a thing called Proposition 8 in California for gay marriage, and it was on again, it was off again, it was on again. But all the things that he has lived through, and then to have his husband die hit by a car on a bike. I mean, it's just unbelievable story. But if you spend a little time, get to hear the relationship and whatnot, I think it really mattered, and it was we're waiting on a mediator's proposal right now, actually, but it was a very good experience with the mediator taking the time to get to know the surviving spouse a little bit. And he cried, and he got to open up. And for some of them, if they don't get a chance to go to trial or whatnot, their mediation is sort of their day of justice. It's their day of deliverance, where they get to spill out and talk about what's happened to them. And sometimes the best practice for you as a mediator is just to listen and, be a little bit of show some empathy. And as opposed to this deal where, we're going back and forth, and it's like we're buying and selling carpets sometimes. We spend time explaining to them that this isn't about the value of your spouse, and there's no amount of money, but, they need a time to be able to kind of work through the emotions, and that potentially the mediation is closure for that loss. So it takes a little time for them to process what's going on. It's new to them, and it allows them, when you're asking questions and then listening, and tell me about Mikey, or tell me about Joe, or tell me about Mary, and what kind of person they were. If you spend a little time, even 10 or 15 minutes on that, I think it goes a long way in the mediation process. It really helps them to process, what's going on. And again, if a case settles, which most cases eventually do, that's their day of justice. If you think about it, is that mediation day. That's the day that they get a chance to be heard, I guess would be the right statement on that. So maybe I'll just open it up to you, Geoff, a little bit, if you want to be able to do a little back and forth.
Yes, thank you, Geoff. That was a terrific set of insights and a great way to begin our conversation. Let's talk about client expectations, because you talked about the mediator's role and the lawyer's role in perhaps engendering unrealistic expectations and then bringing them back down to planet Earth. When people come to a prestigious firm like yours with a track record of getting big verdicts and great success for people, how do you keep people's expectations in line, keep clients' expectations in line, and prevent them from getting carried away? Or is that possible?
Well, that's a great question, actually. And that starts from the very beginning of when you interview the case. Because there are cases where you just have to say, I'm not the right lawyer or law firm for your case. Years ago, Bruce Broilett and I, we interviewed a case, and it was a Ford Firestone rollover case. And it was a death case of a daughter, and it was her parents who were in there. And it was a very good case on liability. But after about 20 minutes, it was obvious that the father of that daughter that had passed away, he said he wanted the engineers from Ford to go to prison. He wanted the head of Ford Motor Company basically to be drawn out in the county, the city square, and hog-tied and, flagged with a whip. And, it was obvious to us, and I'm using an extreme example that actually was close to what he said. It was that, some people, you can't control them. And so for us, it starts with case selection on that. If I have a person I don't think I can control, I'm just not going to take the case. Now, somebody's going to take that case, and they're going to have to deal with them. And ironically, many years later, we ran into the lawyer that did take that case and said it was the worst mistake he ever made was to take that case, by the way. So, that's it. So you have to start with, we cannot, if it's a death case, we cannot bring your loved one back. This is not a criminal proceeding. This is not a situation where you're gonna get a pound of flesh. So early on, the lawyers have to start with that. But a lot of the young lawyers, they might oversell the value of the case because they're competing to get the case with other law firms. So then they get in there and then they're way over their head and they're out over their skis, whatever the term you want to use. And it becomes really difficult on that. And that's why those cases, to me, are ones that are going to take more than 1 or 2 sessions of mediation, because you've got to start with this, way pie in the sky damage demand number, and then you got to work it down. The other side of that is the lawyers that start too low. Because I speak in conferences and lawyers will come up to me, I got this case, it's worth $500,000. How much do you think I should demand? And I said, well, what do you think you should demand? They go, like 575. And I know, and we all laugh at that because we know that if you demand 575, you're going to settle that case for $200,000. So I have told them, and I think the more experienced lawyers tell the younger lawyers, you got to demand over twice where you want to end up, because everybody looks at the midpoint. And it's an unspoken rule, but we all know it, the midpoint of the midpoint of the midpoint, right? That's what goes on now. And so, but a lot of lawyers don't know that. And if you don't know where they want to end up, and they say they want to end up at 500 and their demand's 575 or 650, you've got to talk to them about that before they make that demand. And that is that's the other side of that, Geoff, is that the too low one. The too high one, you can go, what do you base that on? What do you base that on? Is that a verdict? Do you have any verdicts in that range? How many trials have you had? The ones I have found, the more experienced trial lawyers are probably a little easier to deal with on some of these, to a point. If they don't want to settle the case, they want to try the case, great. Then they're going to stay high and they're not going to move. But I think the other thing that comes into play, Geoff, is that sometimes the lawyers feel like if they're civil and they act well, that they're showing weakness. This is a thing that goes on now. So we got a lot of these younger lawyers, they want to be tough guys or tough gals, and they're going to come in there and they're afraid that their client's going to think they're weak if they show decency and civility. And I'm working on that from the plaintiff's bar. I'm having people talk about it at seminars and whatnot, but it is an issue. And maybe you can, as a mediator, you can say to the lawyer in front of their client, by the way, I know your counsel. He's very good, or she is very good. Don't confuse her being very cordial with me and whatnot, being professional with weakness. She is not weak. She's tough. I know that. We all know that, or something to that effect in front of the client. That might help, lower the temperature on that issue.
Yes, when I was a young lawyer, I heard a talk by Ellis Horvitz, late Ellis Horvitz of Horvitz and Levy. He was speaking to the barristers of the Beverly Hills Bar Association. And I'll never forget, he began his comments by saying, over the many years, many of our most crushing defeats have come at the hands of perfect ladies and gentlemen.
Yeah, that's right.
And I that has stuck with me, Geoff.
Yeah. I'm just going to add this, because I had the benefit of being a defense lawyer for 3 years beforehand. What I tell the plaintiffs' lawyers in private, said, listen, you're going to get a lot more honey, or a lot more flies with honey than vinegar. You may not think that, but I know, because I was there. And when I had to deal with the jerks, I would make sure that I screwed them over the last 5 or 10,000 if I had to. And if I had to deal with a guy, we used to have a lawyer named George Moore in Los Angeles. I think he's passed away now, but he was the ultimate gentleman. Charles O'Reilly. Bruce Broilett gave me this great quote. He said, insurance carriers love to pay Charlie O'Reilly money. Why is that? Because the guy's not a jerk, and he's honorable, shows decency, and is talented, And I find the most talented lawyers do not need to be jerks, but you guys have to deal with them on these cases. And part of the reason they're that way is they went to a Jerry Spence seminar, or they went to one of these seminars that someone told them that's why you can't be polite, you got to be tough, you can't be civil, it shows weakness, and you got to take them out, and blah blah blah. They get that information on our side. And I'm trying to help balance that, but it's there, just so you know.
It's yes, I understand your point entirely. Let's go back a little earlier in the mediation process. And I hear from a lot of mediators, and I've experienced myself sometimes, the plaintiffs' lawyers who completely want to shield and insulate their clients from the mediator, won't allow the mediator in the room with the plaintiff, him or herself, much less engage in conversation. I guess there's a fear that the mediator is going to browbeat or bully the plaintiff somehow into taking less money than they deserve.
Yeah.
What's your view on that?
I mean, if you're not going to allow the mediator to meet your client, why are you going to mediation? I mean, seriously. I think in order for a mediator to what I tell people is this, there might be, as you all know, several steps down the road where you're at an impasse and you've got to do a mediator's proposal. I mean, it probably happens on 25 to 40% of 50% of the cases now. How in the world is the mediator going to be able to do a fair mediator's proposal if they don't know what kind of a witness your client makes? I mean, that is part of the sauce that it goes into all this on evaluation of a case. And I just think the way you handle that, my read on that is the way you've got to start with handling the lawyer at a pre-mediation phone call to say, hey, tell me about your client. Is he, how do you feel? Is he a good witness? Is he tough? Is she scared or whatnot? I've heard them say, well, they're scared of mediation. Well, how the hell do you think they're going to be in the courthouse in front of 60 people during voir dire that they've never seen before? You think they might be a little scared during that? I mean, come on. You've got to put your chips on the table. If you got to save a couple of key pieces of impeachment evidence for trial, blah, 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 I get it. But you need a read on the plaintiff and you need a read on the defense. And you can't do that without meeting them and getting some chance to, we used to be in an office where you would come into the conference room and sit and chat with them for a little bit. Now we do it on Zoom, but I think Zoom is a hell of a lot better than a conference call where you can't see the expressions on their face or get a feel for them. You need to be able to have that connection. And I think it's so important for the client to have that connection with the mediator because they have to trust you. Because at the end, there might be a mediator's proposal and they have to trust that you're being fair to them. How are they going to have that relationship if the lawyer shields them from the mediator in the mediation process? So that's my read on that. I understand some of the employment cases, people are that way. I don't do the employment cases myself, but you've got to have that lawyer spend time with the client. They need a lot more hand-holding in the employment whistleblower employment cases. We do a lot of those with doctors that are whistleblowers, believe it or not. You can imagine how tough they are as clients. And I think you've got to maybe make one or two calls before the mediation to open that up possibility up. If you're feeling that resistance, they need to make the calls to say, hey, I think it's really important that I make a connection with your client. Don't you agree? And I mean, I think people that know what they're doing are going to agree with that.
But you mentioned the advent of Zoom, and we've been doing a lot of mediations on Zoom for 5 years now.
Yeah.
Let's talk about the pluses and minuses as you see them of mediating online as opposed to mediating in person.
Yeah. So I think it's here to stay, obviously. I mean, look at us here. I mean, Natalie is in Normandy, France right now. Think about that, here we are. So I had a mediation this week. What day is today? Thursday. I had a mediation on Monday this week. My client, I had never actually sat with him in person. I met him, I interviewed the case online, signed the case up online. He had his depo online. We prepped him for his depo online. I didn't even know how tall the guy was. I think about that. really how tall he is, or he's sitting in a chair. So we asked him, hey, do you want to come into the office for the mediation, or do you want to do it by Zoom? He goes, I'd really like to come into the office if I could. I said, I would love to have you come into the office. Comes into the office. By the way, he's about 5'9". So, I didn't know, but I didn't know. But anyway, we sat in the room, and, he was looking at the brief. He's looking at the exhibits with the brief as a death case for his husband, started crying. I mean, we had a moment where you don't have that moment necessarily on Zoom with the plaintiff. But as a result of that, the mediator came on and saw that, he was having a moment and was able to say, hey, how are you feeling? And I know this is hard. I want you to understand this. We're not negotiating the value of the life of your 30-year spouse. There's no, it gives an opportunity to be able to do a little bit of both. But is Zoom as good at being in person? I don't think it is. I don't think it's as good as being in person, but it's a hell of a lot better than a conference call where you can't see the person's expression, one. And I would say to the lawyers on the plaintiff side, especially if you're able to do it, have them come into your conference room for the mediation. At least they're in a room where they can talk during the breaks and you get a chance to bond a little more. And that's what builds that trust, is that time together. It takes time to build that. So
Geoff, when your clients are not necessarily corporate business executives who are accustomed to being on the 30th floor of a 50-floor building downtown,
right.
Is it sometimes the case that your clients are more comfortable and at ease when they're sitting at the dining room table or in their home office, whatever arrangement they have at home, and their dog is sitting next to them? Is it sometimes easier for plaintiffs in injury suits, the kind of cases you handle, to be at home?
So the answer to that is yes, it is. And a lot of it depends on where you practice. So I'm going to give a good example. I had a case with a little girl that was with her mom and dad that were at a IKEA, and she's over there looking at something. The shelf comes down, hits her in the eye, and tears the white matter of her eye. I mean, it's just gruesome. The blood and the whole thing right out. 4 or 5-year-old girl. And they live way up in the North Valley part of Los Angeles. For them to come to my office, I'm in Los Angeles now, in an area called El Segundo, but for many years in Santa Monica. But for them to come to my office, hour and a half in traffic each way. They got dogs, they have another kid, they got a babysitter, all of those things. We are able to do that Zoom very effectively with them at their home, at the kitchen table. The girl was able to be there, come on camera, come off camera. She could look into the camera, you could see. She had what's called a lazy eye as a result of that. You could see it on the camera, and it was much better for them. So there is definitely a role for that, and it is better actually because of if you live in a city with 10 million people and you got traffic, or now we got wildfires. I mean, think about that. There were mediations going on during the wildfires. And people are going, I think I got to leave my house. I mean, that really happened 3 weeks ago. I think there's smoke out in my driveway. I think I better leave my house. But anyway, it gives a lot more flexibility for the clients, and definitely if they're properly prepared before the mediation, where you talk to them, you're in your own room, and we get a chance to talk to them on camera when we're in our breakout rooms. So I use that time to talk to them and get them maybe to listen to them and get them to talk. So yeah, it does work, and it is better for a lot of people, especially people that are working people that don't want to miss, as much time from work. If you have a half-day mediation, they can go to work in the afternoon or work from home. People work from home. So yes, on that.
And can you think at the other side of the coin, a circumstance when it was essential to have a client come to your office and be in person for a mediation?
Yeah, many times. I think if you have a difficult client for the plaintiff, it's better to have them in a conference room at your office. And what does it do? It gives them a chance to kind of focus. They're not distracted, because there's distractions when they're at home too. So they're distracted. They got, somebody telling them, "Oh, your lawyers suck, or you're not getting enough money." You got a bunch of wannabe lawyers trying to tell them they're looking at YouTube and saying that, you got $4 million for this case, and the case is worth 125,000, So you get a chance to have them see your office, focus, conference room. They get to listen to you. I think there is a definitely a plus of that, especially with the more sophisticated almost plaintiff on that. Yeah.
So it's case by case.
It is definitely a case by case.
Yeah. So now moving through the mediation process, one topic that seems to be an endless area of interest and controversy in some sense is the opening joint session.
Yeah.
Some lawyers say, oh, just dismiss it out of hand and say, we know exactly what they have to say. We don't want to have to listen to their dog and pony show. Other lawyers cherish the opportunity to put their best foot forward. And that too, I suppose, is going to be case by case. What are some of the considerations and thoughts that you have in that regard?
Well, the first thing that's important to me is who's in charge of the money. So if the lawyer's in charge of the money and the lawyer's taking the deposition, you probably don't need that joint session. If the claims person is telling the lawyer what to do, and the claims person is in charge, and the claims person is, and I have a good plaintiff, the claims person has never met this person. They read a depo summary a year ago of one of 400 cases that they have. I want them to come in and meet the plaintiff and figure out, if I'm paying somebody millions of dollars, I want it to be somebody that's not a jerk. I want it to be a family that is going to make a difference. And so by having a joint session, at least allows some of that opportunity. Now, there's other ways to do it. Bob, many times, who's on here, will have the claims person come down and go, "Hey, can they meet your clients? They want to meet your clients." We had a case where we had it was called the FedEx bus explosion case. 30 kids from Los Angeles on a bus going up to Northern California for a college visit. These are mostly kids from underprivileged areas, first ones in their families to go to college. And it was a big deal. And they were all getting scholarships to the University California system, and they were at Humboldt. While they're on the bus on the I-5 freeway, a FedEx truck is coming the other way. The guy falls asleep or has something, and he comes across and hits that bus head on at 60 miles an hour. There's a 150-foot flame plume going up in the air. There are kids get burned to death in the bus. I mean, it's horrific. I had a boy that was in there that was a quarterback on the football team, and he could hear his friends dying and burning to death. And he had to make a decision whether to break the window and dive out or go to the front of the bus and try and help the kids. And he said, "I thought about my mom and dad. I'm the oldest kid in our family. It's a Hispanic family. I'm the only one that's going to go to college. If I die, my family will never recover." He dives out. Amount of survivor guilt that kid had, it was unbelievable. I mean, it's just unbelievable. That kid, and he was a tough kid, let me tell you. He was a tough kid, and he, we wanted the people that are paying the money to meet him. There's a kid, that grew up in Oxnard, California. It's kind of a farming area where they pick strawberries, man. They pick cauliflower at 4:30 in the morning. I'm sure Trump's up there trying to deport all the guys right now. Guess who's going to pick it? And that's his mom and dad, who that is. And this kid is going to go to college on a scholarship from the University of California. And he had survivor guilt. And he had so many things going on. And they came in, the claims adjuster left the room, was crying. So I feel it right now. Sorry. But I remember that kid, he testified in front of the California Senate about bus safety. There are 4 things that the NTSB made a rule change on exit windows as a result of that kid testifying in front of the California State Legislature. True story.
Wow. So with respect to joint sessions, there's a concern or fear sometimes that they will get out of control, that the plaintiff's lawyer, we hear concerns from the defense that the plaintiff's lawyer will be bombastic and a flamethrower and do the sort of opening statement that one might give to a jury. And it'll just it'll throw everything off track.
Yeah.
What guidance do you have for your fellow consumer attorneys with respect to those concerns?
Okay, so I've worked with Brown Greene for 33 years. When we used to do these joint ones, that's exactly what he would do. Uh, I just think if you've got a situation where you've got that going on, you don't do the joint session. I just don't see any plus in it at all. I think it'll just make people dig in their heels. The lawyer feels like they've got to put on a show for their client, and they've got to fight for them. And if they're not fighting for them, they're going to fire them and get somebody that will. I mean, that's sort of the mindset a little bit. So I just think if you have someone that's going to, really try and shame the other side and whatnot, I just don't think there's a benefit in doing a joint session with those kind of personalities. So it's a case by case basis, but you might be able to pull him off into a separate room and have him talk about the case away from the client. That's a possibility that I would do with that, because once you're in the room with the client, the gloves are going to come off. I don't care. It's the human nature almost. And so I think if you can bring them into a third breakout room and say, look, they want to hear your main points without having to put on a bunch of an act. And you maybe can do it that way. But the joint session in front of the thing, trying to humiliate the defense and whatnot, disaster. I just think.
So your coaching to your fellow consumer attorneys is, don't do that, but put your best foot forward in a different way.
Yes, don't do it. The thing is, and I come back to those words of honor, integrity, civility, and decency. Those things start in your office. They start in your office with the people that work for you, the people that work with you, the people that work at the courthouse, the people that are taking the depositions. The people that are abusive and do these things, Geoff, they're bad at all of that. I hate to say it, but I bet if you had a little person follow him around, you'd say, oh my God, did he just use that tone of voice with his assistant or his secretary or the clerk? I mean, so yeah, I am promoting trying to get us back away from chest beating and braggarts and and billboards. Don't get me started on the billboard.
Well, we'll talk about the bus benches instead, I suppose. But
Yes.
you've mentioned that a couple of times, so I want to give you the opportunity to comment that has some broader societal impacts, doesn't it?
Terrible. Well, one of the things I've got to do is during COVID, I mean, some of us were working at home. I had no idea what was going on in television during the day. I mean, it's just one lawyer commercial after another. And then you drive around. I'm over here in Arizona right now, going to go to spring training, Dodgers Cubs this afternoon. There's 100 billboards, Top Dog and Sweet James and blah blah blah. You guys all see it. Terrible. I have started a committee in California, an ethics committee, where we're going to try and address it. But the First Amendment's a problem, and I have to get the lawyers to try and police themselves. People will say, "Good luck with that," but I'm going to try though. We're going to try and do some things that we can do some restraints. But it's terrible for the system for sure. Terrible when the jurors get up there and look at you like, are you Sweet James? It's awful. And here we are, we're trying to get justice for people, get a fair resolution on the case. And what do they see? Greedy trial lawyer, money bags, John Morgan, I mean, God, it's right on the 405 freeway. You can't get away from it. So we're all having to deal with it. But at the end of the day, we've got to try and find a way to help police ourselves. Part of the way you do that is by showing decency and civility to others, and including your staff and the people you work with, and including the mediator. Some people are abusive to you guys and gals. I can't understand it, but it is. But there is pushback. I want you to know that. There is leadership pushback, at least in my state, to try and turn this around, to push back the other way. But it couldn't get any worse than it is right now.
What is the sort of errant conduct toward mediators that comes to mind, and what are you doing about it?
Well, that's a great question, actually. People talk, all the lawyers talk, who's a good mediator, who's a bad mediator. Oh, don't use this person. Oh, that person's good. I mean, it is such a subjective thing. A person has a good case and gets a good result. they're going to go, hey man, Bob Tessier is the best mediator ever. he got my case resolved. And then the next week, the guy will say, you know, Bob Tessier, he sucks. He didn't get the case resolved. So it is such a subjective thing that I don't know how much control you really have over it, honestly. All you can do is stick to your guns, you know, show fairness to both sides, try and do things the right way, listen to the clients, listen to the lawyers. But at the end of the day, it's a very, very subjective thing. It really is. And
Yes, when you mentioned, though, Geoff, lawyers engaging in abusive conduct toward mediators,
yeah,
I'm very curious to know what comes to mind.
well, some of these lawyers will just they'll you know put out. We all have listservs now, right? We all have listservs. So if they have a bad experience with a mediator, they're putting your name out on that listserv, saying so and so sucks, and you know I had a bad experience, and this and that, and so there's nothing you can really do about that other than to try and do the best job you can do. And the people that get a good result, they're always going to say you're a great mediator, right? That's what's going to happen. So you have to, you know, have a thick skin, and you have to just keep putting one boot in front of the other, in my opinion, and keep doing what you're doing. There isn't a lot of control that you can have over that other than just trying to stay above the fray, be decent, and be fair to both sides. I mean, that's what you can do. I see a hand.
Yes, we're going to get some questions just in the last few minutes. I had a couple more that I wanted to get to.
Sure.
Let's talk about extreme opening demands in mediation. One comment that we sometimes hear about the consumer attorneys is they start with such pie in the sky numbers. It's very difficult to keep the defense engaged. What are your thoughts on bargaining strategy at the beginning of the bargaining?
Well, that's, to me, is why that pre-mediation phone call is so important. Because if you smell out one of those demands, the case is worth 100,000 and they're demanding 5 million. I'll use that as an example. But you might be able to talk to that lawyer at a pre-mediation phone call and go, what are you thinking about demanding in the case? Do you have a thought on that? Or they say, yeah, I'm thinking about, probably going to come in high, and kind of thinking a range. Yeah, I think I'm going to come in around 5 million. And then you can talk to them a little bit. Say, all right, well, how do you think that's going to be received by the other side? Well, screw them, blah, 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 blah. But they always start out really low, and I can do that. Well, don't you want to engage them, though? Do you want to try and get them at least to have the number be low enough so that they'll respond, but high enough that you have a lot of room to move? Yeah, I do want that. All right, well, 5 million isn't going to do that. I mean, you just got to tell them, you got to go 5 million and do it. I've had times where I've been too high, and I'll say, well, where do you think I should go? And they'll say, why don't you start at like 3.5, 2.5? Why don't you start at 1.5 million? I think that's a better, most lawyers will listen to that. Now, they might not agree to that number, but they might make a difference between the 5 million and the 1.5. At least it's a little better, because then what happens is if you get in there and the defense says, I'm not even going to respond to that, you'll have to be able to say to them, hey, you're so high that they can't respond. Or they're going to respond with $10,000. What do you want to do? Do you want to try and restart this a little bit, or maybe start with do you want to try and do a bracket right away, or what do you want to do? And you can probably work with, if the plaintiff lawyer wants to get the case settled, they're going to have to recalibrate. I've had to recalibrate before. You don't want to do that in front of their client, by the way. Bad move to do that in front of the client. So you want to do that. That's why if you can smell that out, that pre-mediation phone call, it really helps that, because then you've gained that credibility too when they come back and go, you know what, I said that you maybe need to go a little lower. You didn't, and they're going to start out at $2,500.
Yes, well, sometimes that magic question, how do you think the defense will respond? Sometimes that is appropriately asked in the presence of the client, because sometimes it's the client who's provoking that pie in the sky number. Isn't that the case?
Definitely could be the case, yes.
Yeah. So you also mentioned, would that get us into early bracketing? and that's another controversial, provocative subject in a lot of circles. We have some people who say, "Oh my God, don't pull that on me, Geoff, I hate that." Other people think it's a useful tool in negotiation. Bracketing is, of course, the simultaneous movement of the defense comes up to a higher number, the plaintiff comes down to a lower number simultaneously, in order that neither side thinks that its generosity will not be appropriately reciprocated. What's your view of that negotiating tactic, Geoff?
Well, I like bracketing because what it does is if you've had 3 or 4 moves, 5 or 6 moves, and I'm too high and they're too low, we both know it, but we can't do anything about it. Bracketing helps because what it does is we all look at the midpoint of the bracket, and it helps you move the theater to a more realistic area without actually technically moving. And if you have trust in the professionalism of the 2 lawyers that you're dealing with on either side, and they understand that we're kind of looking at most cases, not all cases, but most cases will look for a midpoint in the bracket, it helps you see if you have a chance of moving the thing forward. And we then negotiate the brackets. So that's what I do. I negotiate the brackets, and I think it's helpful in the right case. I really do. When I'm too high and I can't just drop $2 million. So what do? And so sometimes the bracketing really helps that along because it allows you to make both sides to make substantive moves to kind of telegraph that you're willing to try and get the case done without actually having to do 15 more $10,000 moves.
Yes. And do you have a preference as to the orchestration of those brackets? You said you negotiate them. Do you look for mediators to initiate? Hey, why don't you come to this and they come to that? Is it something that you like to propose? Do you sit in a room together with opposing counsel and the mediator and hash it out?
No,
how do you like to orchestrate?
none of those. None of those. So I never sit in the room with opposing counsel on it ever. No. So what I do, and I don't have the mediator unless I'm worried about them leaving the table on a case I want to get resolved. I might ask a mediator, what do you think would be a good bracket? But I know in my head what the midpoint of the bracket is. So I want to make that midpoint higher than where I want to end up. So I have to make the bracket higher because I might have to do a counter to their bracket 2 more times. So my midpoint is going to be, if my midpoint is 2 million, I'm going to do a bracket of 2.5 and 1.5. If I want to get the case settled for $1 million, I probably want my midpoint bracket initial one to be 2 million. And then the next one may be 1,750,000, and then 1,000,005, and then, moving those brackets, those midpoints is where what I look at, especially if I'm with people that I kind of trust on the other side, is they're looking at the midpoint too. So.
And is one of the reasons that you're initiating these numbers rather than the mediator because you know what your bottom line is and the mediator doesn't?
And I don't necessarily want the mediator to know. I want the mediator to guess that my bottom line is a little higher than what it really is. Because once you get down there, you can't put that toothpaste back in the tube.
Right. And the question of candor with mediators about what your bottom line really is, do you have a view on that?
I rarely will. And again, I'm going to point out Bob Tessier because I've known him for 35 years. I might do that to somebody that I trust that I've known for 35 years. Okay? But that's going to be rare. Rare do I ever disclose what my bottom line number is. Almost never. And and the part of the reason for that is, that bottom line number, gosh, if we're $5,000 apart, does it make sense to walk away? I mean, I worked for a guy that used to walk away over $5,000. We don't do that anymore. We don't walk away when we're 50,000 apart anymore. I mean, so it's sort of a fluid thing. That's why. But I tell a lot of times our clients will say, "What's our bottom line? What's our line in the sand?" I really dissuade them of having that because it's an organic, movable thing. And who knows? I don't know what the jury looks like that we haven't picked yet on the case.
Yes, and in a mediation, Geoff, it seems to me that having too firm a bottom line before you come in really deprives you of the benefit of the mediation process where you might actually learn something.
Yeah, it's a disaster. I really dissuade other lawyers from doing that, and I personally don't. I don't come in and go, yeah. It's $1 million is our bottom line. If they're at 997, we're walking. I mean, come on. It's ridiculous. And you think you're doing a good job for your client by doing that? That's what I tell the lawyers. Do you think that's a good result for your client that you walked away and you're $5,000 apart on $1 million case? It's ridiculous.
And then before we open it up to a couple of questions, let's seek your views on the ultimate bracket, which is the mediator's proposal, which
Yes.
is that not that the defense come here and the plaintiff come here, but you both come to the same number. What are your views?
So I'm waiting on a mediator's proposal for my case on Monday. It's got to be, you want a 95% success chance on that number. And so it's got to be a little something that's a little, what do we used to call it? A shit sandwich, a little bit of a shit sandwich for the plaintiff and a little bit of a shit sandwich for the defense. That's what it is. And if you try and skewer that one way or the other too far, somebody's not going to take it. So what's the point of it? So it's got to be a number that, yeah, I can live with that. And the thing is, for me, like my firm, sometimes I'll cut the fee a couple of percentage points to get the thing done. Now, that's something that the plaintiff lawyer can do, and these guys out there charging these clients 40%. By the way, I'm trying to do something about that too. The 50%, 45% fees to these clients, it's ridiculous, but I'll stay on topic. I think that the plaintiff lawyer has the ability to, cut a little bit to get the thing done for his clients. So I think they're in a good position. Sometimes sometimes the insurance company's got a few more bucks that they don't need to save off the back of a widow or a parent of a child that was killed too. So, I mean, I think there's wiggle room on both of those, but that's the sweet spot that you have to find.
Yeah, so what's the collaborative aspect then, Geoff, between you and the mediator and perhaps even with defense counsel to make sure that that mediator's proposal is only a little bit unsavory and not too bad?
Right. Give you a great example on a case. So let's say I really, 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 really wanted to get the case settled for $1 million. The defense never is going to pay $1 million on the case, and the defense probably never going to pay $900,000 on the case. So what do you do on that? So maybe that sweet spot on that is maybe it's 875, 895. That's from the defense side. The plaintiff side, the sweet spot is 950 to $1 million. That's sort of the sweet spot on the plaintiff side. So where do you want to come in on that? You might want to come in on that at around 900, so that they'll never pay more than 900. They'll never pay 900, and the plaintiff will never take less than $1 million. You got to find the two little sweet spots for the two sides. I know the plaintiff says you'll never take less than $1 million, which means, yeah, probably take 950.
So, Geoff, how do you make sure that the mediator understands what is reasonably close enough to your sweet spot versus untethered from your sweet spot?
That another great question, Geoff. The experienced mediator or the experienced lawyer will say to the mediator, don't do a mediator's proposal for 950. I'm never going to pay it. I'm never going to pay more than 900. That's the defense will say that. The plaintiff side will say, don't do a mediator's proposal for 900. I'm never going to take less than $1 million. I'm never going to take less than $1 million. Don't do it for 900. Then you kind of know that spot between 900 and 950. That's my read on it.
Yeah, so I guess the key is that there has to be some coordination and a degree of collaboration, both for mediators and not just pulling a mediator's proposal out of their ear or any other aperture. There needs to be some consultation about it. And also there needs to be some proactivity on the part of the lawyers to caution a mediator, if it's the lawyer's preference, that the mediator not just pop a mediator's proposal by surprise.
Right.
There be some consultation. So
you got to get a range. You got to get a range. You got to get a range from the defense and a little bit of range from the plaintiff. And then you got to pick something in between those ranges a little bit. That, to me, is the best way to do it if you want the best chance of success. And then you got to also realize, every case is different and who you're dealing with, because some people will walk away over $25,000. It's rare, but they will. So you got to know who the players are and whether they're interested in getting the case resolved or not. But
Right.
if I have a case where there's a I wanted $1 million, the mediator's proposal was 900, and I go to trial on that case and I get 850, I look like a shithead, right? I've wasted $100,000 on costs. I've wasted time. I put the client through that trial. Gosh, over $25,000. Not a good move.
Yeah. David Geffen, you've been waiting patiently. We have a couple of minutes left. Why don't you unmute yourself, please? And what's your question?
Thank you. Thank you. That's very helpful. I appreciate all this information. I'm curious about what you do or what you think the role of a statutory offer to compromise is. Coming into the mediation, if the plaintiff has made a demand, quite often they come back in again. If the mediation, they're now saying, well, that was an early demand and the offer is closed and our case is worth more. But I think on the other side, where the defense is thinking, well, that's the high limit of what we're going to pay.
Yep.
And we're going to be trying to, make a settlement below that. What do you do in that kind of context when you've already got a statutory offer to compromise out there?
All right, that is a great question, David. That issue comes up probably a lot for a lot of people. So I'm going to kind of go through a couple of different steps on that. All right. So the first step is, one of the reasons I don't like doing those statutory offers is because they do become a potential ceiling or floor, whatever the hell you want to call it. That's one. Number two, if you make an early mediation call to the plaintiff's lawyer and the defense lawyer, you're going to be able to find out, by the way, are you taking the position that the policy's open and that you're never going to negotiate below what you think the true value of the case is? You need to know that before you start the mediation. So that's one. Then from the defense, you've got to call and say, hey, are you taking the position that the policy, that it's not a valid 998 offer, or it's not a valid policy limits offer? Do you have a claims adjuster that has authority to pay above the policy at the mediation? Because you need to know that, because it's a complete waste of time if you don't know that. So those are the two prerequisites that would come before you start that mediation. So then you know the answer to that. And let's say they say, and the plaintiff lawyer is going to always say, it's my position that the policy is open. I go, all right, I get it. I know the policy is open. Will your client take the $300,000? At the end of the day, maybe you're not going to move off of that. You want to know that. You want to know, are you going to move off of the $300,000 to get it done, or is that it? Because it's pretty short mediation. Because if the defense says we're not paying the 300 and they're not taking a penny less than the 300, then why are you guys going to mediation? Why are you putting yourself through this? And you might be able to get them to open up a little bit, David, on that pre-mediation call to see if there's some openings there. To maybe we can we'll throw in another 50, or but that's it. Or we're taking the position it's not a valid demand. Sometimes they don't do it right. They do it too soon. They didn't have the records yet, blah, blah, blah. So all of those issues maybe can be flushed out early on, because you got to know what the playing field is before you start the mediation, or you won't get anywhere. Does that help?
Yeah, thank you very much.
Yes, Geoff Wells, thank you for a tremendously candid and informative presentation. This will be tremendous guidance both to plaintiffs' lawyers and to defense lawyers and to mediators as well. We hope that people have enjoyed this presentation and will decide to contribute to the Los Angeles Regional Food Bank in your honor. If people will then inform us of those contributions, we will be delighted to add them to the running total. And perhaps, Geoff, you'll go down in history as the speaker who put the Will Work for Food project over $700,000. I sure hope you are.
I hope so. Boy, we need it in Los Angeles. We got a lot of need right now, unfortunately, I have to tell you.
Amen. Thank you so much.
All right.
And with that, we are complete.